Good evening, everyone. We're so happy to have you. Welcome in. You are at Estate Planning Basics, and we are delighted and actually charmed by having you here. We will start very shortly. Get comfortable, take your shoes off, and don't worry about a thing. It's going to be an amazing opportunity to learn today. Good evening. Thank you so much for being here. We will be right with you. Happy Wednesday. I hope you had a relaxing day. It's the middle of the week. It is almost the weekend. And you guys are going to love our speaker today. He is so dynamic. We will be welcoming our Facebook crowd here in just a minute. I have my living trust and I have it sit on the living room, and I'm a comedian. I just think I'm so funny. So I started writing jokes inside of there and asking my children to look at them before I die because I don't want to waste a good joke.
Can you share one of the jokes, Veronica?
So one of the jokes I put on there was, my daughter, you are welcome to have all of my jewelry. And then I would say, too bad I don't have any. My son, you can have my car. Oh, too bad, my car's a piece of junk. So it's so nice to be annoying in life and in death too. So congratulations on coming tonight. You are taking a big step of having the courage to informing your family members of what your legacy is. It's a courageous thing to do, and it is an absolutely imperative thing to do. I always say, if you don't plan your estate, you're gonna let your state, the state of California, plan it, and you do not want to do that at all. No, sir. So what I want you to do is I want you to relax. I want you to understand that we're going to be sending you a link to the information, and also Ed and his amazing staff have the opportunity to serve, and they're going to make sure that everybody is taken care of. So I want you to relax, take your shoes off, and understand that you're stepping up to some financial responsibility, and we are all so proud. I am Veronica Dangerfield, and I work proudly for Patelco Credit Union because we care about your financial health and your financial well-being, even while you're here on the planet and even when you're gone, because that's just how much we love you. So I wanted to introduce now the lovely fair maiden, Carolyn Wilson. She is the Director of Investments for Patelco Credit Union, and she is here to be co-hostess. Go ahead and take it on, Carolyn.
Hello, everybody. Thank you, Veronica. Can you hear me okay? Can you hear me okay?
Yes, nice and clear.
Great, great. Well, welcome to part one of our estate planning webinar series. Tonight's presentation is all about the basics. Our guest speaker will cover living trusts, wills, advanced healthcare directives, and powers of attorney, and of course, many other things. In 2 weeks, on Wednesday, September 28th at 5:30, we will have part two of our estate planning series. This one will be a deep dive into having that honest conversation with your loved ones about your wishes. So it'll be identifying caretakers for loved ones, creating and storing important documents, selecting decision makers, setting up account access. So we will show you how to register for part 2 at the end of tonight's webinar. For tonight's presentation, our speaker, attorney Edward Cainglit, will present for about 40 minutes, after which we will begin a Q&A session. We apologize ahead of time because this is a very large webinar and we know we won't be able to answer all of your questions, but rest assured at the end of the presentation, we'll show you how to reach out to Ed and his team at Oak Crest Law to request an appointment. Now, allow me to read Ed Cainglit's bio. Attorney Edward Cainglit graduated from the University of Southern California at Whittier Law School. The cornerstone of Edward's practice is to help clients leverage the value of estate planning to accomplish their personal and legacy objectives. Edward achieves this by merging his teaching experience with trust and estate law. Ed and his team offer a client-centered approach to legacy planning by educating and counseling clients throughout the estate planning process. At this time, I would like to turn it over to Ed to start the presentation.
Great. Thank you, Veronica. Thank you, Carolyn. And thank you, Patelco, for being such humble and gracious hosts. I want to start off by saying I feel so special. I'm looking at the participant ticker here. I was telling Veronica that I feel like I am on a game show contestant because there are currently, it is 5:36 and there are 815 of you. I want to welcome you. I want to echo Veronica's remarks. This is your time. You are spending it wisely, and I want to make sure that you get the most out of this. So I want to make sure that you feel comfortable. I am going to explain things. Carolyn did clarify that I used to be a teacher. So one of the things that I try my best to do is speak in a manner that when you are done after these 40 minutes, you feel smarter because you are able to understand this ever complicated topic of estate planning. In 1798, Benjamin Franklin echoed the famous quote of, "There is nothing more certain than death and taxes." And here we are in 2022, a quote that is over 200 years old, talking about a taboo topic, actually. This is a topic that not enough people are being honest in discussing, in planning, and it's just something that people just don't discuss. I want to share a quick story about my experience discussing estate planning with my grandparents. When I was a new lawyer over 15 years ago, I had discussed with them exactly how important this is. And I've actually lost one grandparent currently. And I explained, we got to talk about the house. We got to talk about your assets. My grandparents are immigrants from the Philippines. They've worked really hard. They've acquired assets. But you know what my grandparents told me is they said, in the translation in their dialect, they said, "My dear child, why are you asking these questions? Do you want us to die?" Right? And I said, "No, Grandma, that's the least thing that I want. I want you to live a very long life. I want you to use all of your assets. But the way it is here, particularly in California, is we need to plan, plan, plan. Things just don't automatically happen." And so this is what I wanted to begin with, is this concept of, who do you love? What makes this time important in the sense, if you're no longer here, and there are people who are going to miss you and grieve for you, for example, what is it exactly that you want to leave behind? What memory do you want to leave behind? You don't want to be a burden on a family while you're alive. There's this concept that because medicine and technology is better than it was 100 years ago, we just don't pass away. Statistically, we are physically and or mentally incapacitated up to 7 years, who's going to take care of us, who's going to talk to our doctors, who's going to make critical decisions, for example. And then again, when we pass away, who's going to manage everything? How are things going to be transferred? And so my overarching goal for tonight is that I equip you with the necessary tools so that you can plan appropriately. And then you can live with the peace of mind that you've literally done everything you can to make sure that that next generation is prepared in a way that they can celebrate you. They can celebrate the fact that the assets are being transitioned to the next generation efficiently. And it's really about you, actually, in this concept of estate planning. All right. So what is an estate plan? And it basically is a part of your financial plan. And I want to say this is a controversial explanation of an estate plan, but I want to get this clear to the listeners what type of estate planning attorney I am. I am a collaborative estate planning attorney. When you work with our office, we make it very clear that this is all we do. We don't have secret licenses. I'm not a realtor, for example. I will not try to get you into my office so that I can sell your house or refinance your house. I don't have any other licenses except to practice law. Now, this is important because the way I've been practicing over the last 15 years is you need to assemble a team. And that is why it is in your best interest to collaborate with those certain professional advisors. Now, if you look at my slide, what I have here is I have you, the Patelco member, in the middle. And the way it works is that your attorney, your financial advisor, as well as your other ancillary team, like your accountant, for example, like your insurance advisor, or he or she can be part of the financial advisor. But we need to work together to collaborate, because when you set up an estate plan, it is necessarily connected to your assets, among other things, right? So I can draft a wonderful trust, but what type of assets do we put in it so that we get you from point A to point B, right? Are you 40 years old? Are you 50 years old? Do you have grandchildren? Do you want to make sure that your grandchildren go to college? These are the types of things that are important, and we collaborate. And so this is why I'm so humbled by working with a wonderful institution like Patelco, where when we present to the members that, you know, the real way of doing sound and complete estate planning is to do it as part of the overall financial plan, right? So it's a collaborated approach. All right, who needs an estate plan? It's essentially everyone. If you look at my list here, it's, you know, if you have minor children, if you have a blended family, I have a nice video that you can see. The two that I wanted to focus on, particularly here in California, is if you have real property, that is the trigger. Now, you know, we are California, right? Our real property is very special here. Just having one real property in the right zip code, you're already an instant millionaire, whether you like it or not. And the other category is this 180,000 of other assets. Now, these are important because if you have these, it will trigger this word called probate. And probate is basically a court process that no one on this call, all 912 of you, do not want to go through. A look at the numbers. So it is estimated that about 70% of the American public does not have an adequate estate plan. And so 47 have a will and 17 have a trust. I will explain today what happens if you have a will, what happens if you have a trust, and what happens if you have nothing, right? So those are the three categories: having a will, having a trust, and having nothing. And in most cases, you'll have to go to probate, which can be very long. It can take up to 2 years or more before your family receives assets. Now, you know, we talk about death and taxes. Benjamin Franklin, I wanted to introduce another concept in estate planning, which is a lot of people just assume that they are living on a Monday and then they're gone on a Tuesday. And so in any good estate plan, you need to make sure that the transition plan is in place, right? And so, like I said, statistically, you can be mentally and or physically incapacitated over a 7-year period. And so in any good estate plan, you need to make sure you have provisions that while you're still here with us, you're alive, but let's say you have some sort of cognitive disorder, you have provisions in place that will address those particularities of that plan, because you don't want to assume that you're using it on a Monday and then you're not using it on a Tuesday, right? You just can't say, oh, I want to give it to my favorite child on Tuesday. Well, guess what? While you're alive, you are the beneficiary, you are the owner, you get to benefit from your assets. It's just that you need someone to take care of your assets and decision-making when you can't. So what happens if you die without an estate plan? Some property passes automatically to a joint owner or to a designated beneficiary. So for example, if you have a house and the house is titled husband and wife, joint tenants with right of survivorship, just make sure you have those magic words with right of joint tenant with right of survivorship. That is an example where the way it is titled, it'll automatically go to the joint owner, okay? Or if you designate a beneficiary on these, this is with particular assets. So usually it's life insurance, usually it's retirement plans where when you set these accounts up, you already determine if you're no longer here, who is the beneficiary. The issue with these is that, you set them up when you're 19, 25, 30. Now 30 years have gone by, lots of change in dynamics, relationships, marriage. And I've seen cases, I've inherited cases where the wrong beneficiary is listed because they totally forgot that in 1980, they were married to Sandra, for example. And unfortunately, when they passed away in 2021, they're no longer married to Sandra. They've in fact been married 3 times since then. And this new spouse thinks that he or she is entitled to these assets. So the issue with that is just make sure that it's current. Now, other than that first category, all other property generally passes according to state intestacy laws. And basically what that means is that if you haven't done your homework, if you didn't set up a trust, or if you didn't list a beneficiary, or if there is no survivor, because it's not in a joint ownership situation, then the state decides. The state decides. A famous case named James Dean. Sorry, I hesitated there because there has been newer cases like Anne Heche. I mean, the list goes on and on. When that statistic I listed where 70% don't have proper estate planning included in there are a lot of famous people. So an example of state intestacy laws is James Dean. He died at a very young age here in California, around age 24. And when he died, he was already famous. He was not married. His mother had predeceased him, and he was making a lot of money. To this day, the likeness of James Dean generates about $1 million. And so what happened is, because James Dean didn't decide, state of California decided, and guess what they did? They gave everything to his biological father. Now, for some of you, you would think that that is appropriate and that's a good choice. But the reality of the story in the state intestacy explanation is that, in fact, James Dean's father had abandoned James Dean and James Dean's mother when he was a very young child. So you can argue that state of California got it wrong, but guess what? State of California doesn't care. California is inundated. 70% of people are using the state system to make these critical decisions. So they've already enacted laws that determine, because you didn't, who will inherit. So they gave it to the father. They don't care that he was a bad father. They don't care that he skipped town. They don't care that the only connection was the fact that he was a biological father. So moral of the story is get your orders, get your affairs in order, because no one will make better decisions than you. Okay, so I've talked about probate. I call the P word in my practice. And here's a couple more reasons of how to avoid, and I've gone over a couple of these, which is jointly titled, beneficiary designated. You can also give lifetime gifts, right? So I have a client who has X number of dollars and he is already elderly. He's in his high 80s and he tells me, I don't need it. I'd like to gift it away. Right? So we have gifting laws here in the United States where the IRS pays attention to the types of gifts you're making. On an annual basis, you can give up to $16,000 to as many people as you'd like within the year, right? So there are 941 of you listening to me now. If I so choose, I can give there's 943. Looks like they're listening to me and they're trying to join to get $16,000 in gifts. So if I literally wanted to, I could give $16,000 to each and every one of the 944 now that are listening to me without any reporting, without any issues. The issue is with the IRS, once I go past $16,000, they want to know what I'm giving, right? So there's 944. What I can do is for 943 people, I give you 16,000. And for that last person, I'll give you $1,016,000. And for that person, I will have to report a gift of $1 million to the IRS because whatever I gave past 16,000, that would be the reportable amount. Now, what's the big deal? The big deal is that they're wanting to know who's giving these gifts so that they can ultimately follow you and possibly subject you to some type of transfer tax ultimately. Now, I joke, 2022 is a great time to pass away because that number is at an all-time high. It's indexed for inflation. The magic number is $12,060,000. That means I can pass away with that much and not pay any type of transfer tax, estate or gift taxes, right? So when is a good time to pass away? This year it is because it is at an all-time high. It sunsets in 2026 and it goes down somewhere in the 4 to 5 million range. Now, the final one I've left as the gold standard, which is the best way, in my humble opinion, is to use a trust, right? And we'll talk about how that works. Okay, so I did say that I was going to explain what the difference between a will and a trust and how wills ultimately end up in probate, right? So if you have a home, if you have assets north of $188,000 and you use a will, it will go to probate court. Now, the way this works is there are probate courts in every superior court in every county in California. So an executor is appointed. You have to collect assets, settle debts, pay taxes, distribute property. It's a very formal process. You have to check in with the court and the judge once the executor or the administrator is appointed. And it lasts quite some time. It lasts sometimes 1 to 2 years, depending on the complexity of your county, right? And it's very expensive. And because it's a courthouse, it is public. So I wanted to show off this great video here. So it costs approximately 5 to 10% of the fair market value of your asset. So that means if you own a home, and if it's worth $1 million, that is subject to a $600,000 mortgage, the court will assess a minimum of 5% on $1 million, not the equity. The second thing you need to know is that it takes a long time. It generally takes 1 to 2 years, but there are some exceptions, of course, for the larger counties like Los Angeles. That's where I was born, the craziest county in California. And especially during the pandemic, we've seen numbers like 3 years, 4 years, 5 years, because again, it's just like the freeway system in California. So there's a lot of traffic. All right, so then if a will ends up in probate court, because I have a house, for example, then how does a trust avoid probate court? Now, the way it works is it has special provisions in it. So I talked about make sure an estate plan has incapacity provisions. So there's wonderful provisions that say if I get sick, I'm still alive. It is clear that you are the beneficiary while you're still alive, for example. One common how do I say this? One common concern of a family when they set up a trust is, oh, great, Ed, now I'm going to set up this trust. I'm going to pay you thousands of dollars to do this. But when I set it up, my kids are going to kick me out because I no longer own the home. And that's not true. You actually continue to own the home. You continue to manage the assets like you did prior to, but you've basically set up a safety net. God forbid you get sick or if you pass away. So here's an example of a trust. If you look at the video, it's an agreement between three parties, an owner, a manager, and a beneficiary. And when you set up your trust, you're actually all three of these individuals. You're the owner because you own the home. You're also the manager because you get to decide when to refinance, when to rent, or when to sell. And you're also the beneficiary because if you sell the house, you can benefit from the proceeds of the sale. Now, in your estate plan, while you are the trustee, if you subsequently become sick, you've already determined, for example, that your adult son will serve as the manager. Because you're still alive, you will continue to be the beneficiary. However, once you pass away, you've already decided through your estate plan who's in charge and who will inherit from your estate. When this happens, everything is in place and those individuals will come forward to manage your estate plan. And so that's how it works. Okay. Blended families. Having a blended family where each spouse was previously married or was in a relationship that produced at least one child introduces interesting factors to consider. For example, I represent clients who have been married their third time, and in each marriage, they produce at least one child. In the Brady bunch, Mr. Brady had 3 sons from a separate marriage, and Mrs. Brady had 3 daughters from a separate marriage. If one spouse passes away and the surviving spouse inherits all of the assets, this introduces a level of complexity for each spouse to consider if one of them were to pass away. So in a worst case scenario, if Mr. Brady were to pass before Mrs. Brady, and we assume Mrs. Brady inherited the entire estate, she could intentionally or unintentionally disinherit Mr. Brady's 3 sons, and they could get nothing. That was a mouthful. First of all, I am 46 years old, so Brady brunch was my jam. So I've aged myself. I've dated myself. The second thing, I don't know. Do you guys know if Mr. Brady was actually married prior to marrying Mrs. Brady? We don't know the backstory. I should figure that out. But this is a hot topic these days. You know, when I meet a client or clients, a spouse, a couple, it's quite common to have a blended family. And so I bring this up, sort of modern times, modern family, perhaps out of the 968. My goal is to get up to 1,000, by the way. But out of the 969 of you that are listening, I am going to guess that some of you are in a blended family situation. Now, I did talk about my focus on this collaboration. And I will tell you that an unexperienced estate planning attorney who does not know the complexities and or the sensitivities of a blended family can really cause a lot of trauma and trouble in an estate plan. Because what I see far too often is the oversimplification of estate plans and not being sensitive to this blended family dynamic. An example would be the family home, right? If Mr. Brady were to pass away and there was a provision in there that said, okay, well, his 3 sons get 50%, that could necessarily mean that Mrs. Brady is going to be kicked out and or bankrupted from the family home. The family home, in my humble opinion, is the castle of the married couple. And that is a special asset that needs special handling. And this is where the power, the benefit of working with a financial team like the wonderful people at Patelco can come in with muscle, with bandwidth to assist us in this type of situation. So an example would be that we have special assets that we consider in a blended family situation. We come in, we meet with our clients, and for example, what do we do with the boys? What do we do with Bobby? I get the other, Greg. What do we do with them? Because we don't, you know, Mrs. Brady was their stepmom. We can't assume that she's going to treat them the same way as she's going to treat Marsha or Cindy, for example. And so one of the things that I've done quite effectively is identifying assets or asset classes so that when Mr. Brady does die, there are assets that go nice and easy to the boys, like life insurance, for example. I think that is a wonderful strategy because we don't need it until we actually need it, right? And we don't have this situation where the boys are pressuring their stepmother, oh, you know, I wish you would die, stepmother, because that is the only time that I can take part in the estate. And so it's this dynamic. So food for thought for the 961 of you guys that are in blended family situations. I want to let you know that this is a special planning consideration, and that if you are in a blended family situation, that make sure that your estate plan is sensitive to that type of dynamic. All right. So I'm making sure that I'm always good with time here. And yes, I'm ahead of schedule. I wanted to spend a little bit of time on how this actually is, because I'm sure some of you are like, Ed, how much is this going to cost? What is the investment in an estate plan? But before I jump to that, I wanted to go over what the reality of is in setting up an estate plan, right? So the No plan, which is the James Dean plan, the Anne Heche plan, the Prince plan, for example, Prince died. He didn't have an estate plan. Who else had an estate, didn't have an estate plan? I think Aretha Franklin didn't have an estate plan. And that's the plan where the state of California decides, right? You're going to go to probate and it's going to cost minimum 3 to 5. I say the average probate fee is about 8%, right? So in my example, if you own just that $1 million home subject to a mortgage with only 400,000 of equity, that home goes to probate, you're talking about 5% of $1 million or $50,000. Now, there's some of you that are like do-it-yourselfers. You know, you're the types that go to the free clinic at Home Depot to learn how to tile your cabinet or your kitchen, right? More power to you. I actually love, capital LOVE, LegalZoom. Why? Because they do all my marketing. And my average client that uses LegalZoom sets it up, pays the $750, doesn't follow the instructions. They come to my office and nothing's done. So these are forms driven, no accountability. Again, likely will end up in probate. And again, remember, when you go to probate, you'll have to hire a lawyer. So I don't want to say this, you know, like the way the nurses, you know, trick you into saying nurses get you in the end. My wife is a nurse, but lawyers are like that in this capacity, because if you end up in probate, you have to be represented by a lawyer who, again, takes those fees. Now, then from there, we have this sort of category. We have attorney with multi-services, or what I call them, attorneys who are general practitioners, just like general practicing physicians, right? They're good for scratchy throat, they're good for ear infections, but if it's stomach cancer, you need to go to someone that just does, you know, stomachs, for example. So there's different price points here. I would say this is on the low end, 500 to 1,500. I've seen lower, believe it or not. And then there's just, this is all what we do. So I only practice in estate planning. I have drafted thousands of estate plans. I've administered, that means my clients have passed away. I've administered hundreds of trusts. I think it's almost in the 300, 400 range. And then we do probates as well. That is not a primary area of my practice. Again, probate, in my humble opinion, if you go to probate, that means you've sort of failed in the estate planning, because we need to plan. And so those normal rates are about $5,000 to set up the trust. And then to administer, you're looking at a very minimal amount, 0.5 to 1%. So that's an example of how it really is. Now, in our estate plan to avoid probate, here are all of the items that come in a basic estate planning package. You have the trust, you have the certificate of trust, which is an important document that you give financial institutions, you give it to realtors, you give it to escrow officers so that when you purchase homes, it needs to be in the name of your trust. There also is a pour over will. A pour over will basically is a backup to the backup. You already know that wills go to probate, but what if you have 10 properties and for whatever reason, 9 of them are in the trust, and that 10th, because you refinanced a year ago because the rates were so great, excuse me, and the lender forgot to put it back into the trust. This is a real story. So you have a trust that will take 9 of your 10 properties privately out of probate, but that 10th one, what happens to it? Because it's not in the name of the trust. That 10th one, unfortunately, will go through probate because it was never returned to the trust. And what we do there is we use a pour over will. And it's a special will. It's not just any other will. And the will basically says, I have a trust. I forgot to put this asset in the trust. Please transfer it to the trust. So we take it to probate court and it gets signed off. Still probate, however, so it's still a public process. There are also documents to take care of your personal well-being, right? So we have the Advanced Healthcare Directive. Inside of that directive, we have a healthcare power of attorney. We have the end of life directions, as well as organ donation instructions. There is also a HIPAA waiver. Privacy is a big thing these days. And so what this HIPAA waiver does is it allows third parties like your spouse, like your children, or whoever you trust to receive otherwise private medical information. In addition, the list goes on. There is a durable power of attorney for finances. This document is important while you're alive and if you're incapacitated. This document will allow someone else to sign your name. These documents are what I call supporting or ancillary documents to the trust because the provisions in the trust are spread throughout the rest of the document. So for example, in your trust, if your favorite son is the successor trustee, well, guess what? Your power of attorney will be your son as well. So we have you bases covered. If you need someone to file your taxes while you're incapacitated, your son can use this power of attorney. We also will take care of your real property in California. We also can take care of properties out of state, by the way, but it comes with one real property transfer. We will prepare a deed to transfer that effectively into your trust and we'll file it with the appropriate county recorder and assessor's office. Your property taxes will stay the same. Every now and then the assessor gets it wrong, but part of this service is telling them that they got it wrong and to return it to the low amount. If you have minor children, it also comes with a nomination of guardian, as well as a nomination of conservator for you if you need one in the future. Personal property memorandum, these are the things that people overlook. I recall in the estate of a famous person, and it was a wonderful estate plan, but he had a lot of personal property. He was Mork of Mork and Mindy. I just can't think of his name. Perhaps Veronica will remind me towards the end when she comes back. But anyways, in that estate, they fought about personal property, paintings and things like that. So we want to make sure that we effectively transfer all of your property into the trust. And if you have special instructions, for example, like in Veronica's situation, she's giving her daughter, her favorite daughter, the jewelry that she doesn't own. Funding instructions is very important. This is instructions on how to properly fund your trust. Michael Jackson in 2008 had a great trust, but unfortunately it was not funded and it still ended up in probate. So the idea is that all of your assets are actually transferred to your trust, are transferred trust, with the exception of the retirement accounts. We keep that out of the trust because of taxes in the future. Robin Williams, thank you. That's Tara from my office. She helped me with that. Now, I want to talk about 2 more: assignment of personal property, which goes with the personal property memorandum, but the letter of wishes. This is a non-legal document, letter of wishes, but what it does is it is the bow to the estate plan, because the estate plan is a present. And this letter of wishes is very particular in my office. It's written on paper, like the good old days. You're using a blue inked pen so that it is easy to determine that it's you and it's an original. And essentially it is your last I love you letter to your family. Why did you give Junior 60% and Sally 40%? Well, because Junior has special needs. Sally is independent. She has a family. And this is where you put reasons, for example, why you're giving 25% to charity, right? And I will tell you, having administered hundreds of estate plans, out of anything in this book and binder, what is worth $1 million to your kids is this letter of wishes. They will hold it, they will cherish it, they will read it over and over, and they will tell me, thank you a million times for encouraging my clients' parents essentially to write this letter of wishes. They love, love, love it. Okay, so here it is. The basic estate planning package, it's special pricing for Patelco Credit Union members is $2,950. Now, I will tell you that if you were to call my office, and you should try this, if you were to call my office, my regular estate planning fee starts at $4,850, and I have been practicing for almost 15 years. Now, in order for you to take care of a special price, you have to schedule your consultation by October 14, which is a month's time. So I hope in the last 39 minutes, I've been able to enunciate reasons why you should set up an estate plan. For those of you that need financing, we have effectively and efficiently partnered with a firm. And so my team is ready, willing, and able to assist you with financing as well. All right. Hey, look, Veronica, Carolyn, I stopped right at the 40-minute mark, just like I promised to you.
Perfect. Perfect.
It was amazing, Ed. Thank you so much. It was amazing.
We will get to our Q&A. Ed is going to leave this one slide on with contact information there and a QR code. If you're familiar with a QR code, all you have to do is put your phone up to there, take a picture, and it will get you to the scheduler. I have a couple of questions already that were sent to us prior to the webinar. So I'd like to get to just a few of those, and then we'll get to the other ones as well. So here's one from Gina. My mom is alive and well. My mom's will is already written up and has been for several years now. When my father passed, my mom fixed her will, passing down our family home to my brother when that time comes. I have heard that the will can be written in a different couple of ways. One way causes the family member that inherits the home to have to go through probate, and the other makes it a smooth transition. What is the terminology we should see in the will that would signify a smooth transition versus my brother having to go through probate?
Thank you, Carolyn. You know, this is a great question, and this is a question that reflects how complicated this topic can be, where it's so much to the point where people, you know, just sort of shove it under a rug, right? But I'm happy to clarify this. And if I can answer just this question, I can go to bed at night knowing that I just tried helping one person here, because I think this is a critical question for people to understand, which is, at the end of the day, wills are a guaranteed invitation to probate. No ifs, ands, or buts. So no matter how wonderful your will is, you are going to probate. There are no magic words that you can use to avoid probate. Now, if you don't have significant assets, so if you don't have a home and everything else is less than $188,000, then you can use a will and it will not go to probate. But in this question, she referenced a house specifically. And I'm going to safely assume this house is more than $50,000 because we're in wonderful and beautiful and expensive California. So if this house is in this will, there are no magic words. It will go to probate. She really needs a trust.
Okay. This next question is from Paula. What is the best way to hold real estate? owner occupied, no second homes, etc., so that it passes to your heirs with the least tax implications. 1, form an LLC. 2, POD title. 3, place the property in a trust. 4, place the heirs on title as joint owners. Now, we get that question a lot. And number 5, if there's another.
Great. I love this. This is definitely top 10. Loaded question. I want to talk about the tax issue real quick. So when you transfer assets at death, whether it's probate or whether it's a trust or a will, something magical happens in the United States. It's called adjustment of basis. And what I mean by that, if this home was purchased for $100,000, and when the house is transferred at death, it's worth 1.1 million, you have a gain of $1 million. So if you transfer it at death, it gets adjusted to the then value. You sell for the value, 0 capital gains because of that adjustment, right? So they reference taxes. So if you want to be wise about, capital gains taxes, make sure you transfer it at death. Do not add your child as a co-owner, because that is the opposite. It's called carryover basis, where your child will get your 100,000, not your 1.1. So that's number 1. Number 2, LLC, is this a business venture? Are we doing something complicated? Do we need asset protection? That might be recommended. The gold standard, again, is a trust, because it will avoid probate. And because of the triggering factor, it doesn't get transferred till death. You get that basis adjustments. So whether you have an LLC, you'll still need a trust. The LLC issue is more one for what other factors are there. Is it a rental property? Are there 16 units? And are these 16 people going to sue you? You might need that LLC protection, for example. Now, this person mentioned a payable on death strategy. That is good, but it has issues with it. Number 1, it's fairly new. And so we don't have the breadth of the challenges. So POD is just like life insurance, just like a retirement account. It's a way to transfer real property in California, where if you die, it gets transferred. Now, here's the thing. Remember, I talked about in any good estate plan, you should have incapacity planning. So if you really want to rely on a POD, and again, I mean no disrespect, you must die. What do I mean by that? You need to jump that cliff. You need to do it, pull the cord. Because if you're incapacitated for 7 years, a payable on death deed will not work for those 7 years. You'll have to go to court. You'll have to get a conservatorship, just like Britney Spears. And it is drama, drama, drama. So for $2,950, you should just get a trust.
Okay, that is good. I'm hearing from some people that the QR code is not working there. And the reason is because we've exceeded the monthly scan limit. So it looks like we're going to have to do this the old-fashioned way. If all of you on the webinar here can get out a pen and write down trust at oakcrestlaw.com or call 800-631-1881. And again, we will get you to that. But the QR code, thank you for the messages that I got. It's not working right now, so make sure you jot that down if you could.
We will fix, this is like a good problem to have. I'm just happy that 896 of you are staying at minute 46. I think Carolyn and Veronica, you guys have done a wonderful job. So let me do a quick recap here. We have trusts with an S at oakcrestlaw.com. And then we have a convenient 800 number, which is 800-631-1881. We have the openings to meet with each and every one of you. You can also ask us questions on there. Send us, if we can't get to your question because there's so many of you, please email it to us at trust@oakcrestlaw.com. The other thing that I wanted to say, for those of you that need additional support, I recently did 5 videos that I'm very proud of that are on YouTube. If you want that, you can also email us at trust@oakcrestlaw.com. All right, Carolyn, next question.
All right, here's the next one. I don't have any family members that I trust. Who should I appoint to make financial decisions if I become sick?
You know, this is quite common than you think. And I would say off the bat, the average client will choose a family member to make critical decisions for him or her, right? But I have a significant group of clients that are in this, whether they don't have a lot of family and or they don't trust. So I totally understand where this question is coming from. So a couple of choices. In the state of California, there is a professional who is licensed and bonded called a private fiduciary. So if you Google California private fiduciary, they have an association in California and you can see the different members. I would say that is a option that is affordable. They will help you with healthcare decision making. You know, if you become incapacitated, they can take care of you, and they will also administer your trust. Now, there are other options as well. You can appoint a lawyer. Lawyers, pursuant to their licensing, can do this. Obviously, you can do an accountant, similar as a lawyer. Obviously, that's going to be more expensive than a private fiduciary. And for those of you that have access to a private bank, for example, US Trust at Bank of America, the private bank at Wells Fargo. There are certain financial institutions that also do this, but I generally discourage that because it's the most expensive. How expensive? They'll have ridiculous minimums, like you need 10 million. But you know, people are like that, and they do that sort of as an add-on feature in addition to investing your money. So there are resources out there. It's difficult. Those of you that need further information, send us an email and we can send you a link to the California Private Fiduciaries Association as well.
Okay. This one we've gotten a couple of different ways. I created a trust some time ago. How often do you recommend that I review or update my trust?
Got it. Great one. Again, this is the top 10. So you should be looking at your trust every year on your own. You don't need to meet with a lawyer every year necessarily, but obviously if there's something critical, yes, but you should be reading it every year. Your lawyer that drafted that trust should have a mechanism to invite you back into his or her practice every 3 to 5 years, where we formally review the trust. And why every 3 to 5 years? Because one of two things or both things could happen. There is a asset or relationship change, right? 5 years ago, you were married to that person, or 3 years ago, your best friend was this person. Guess what? Now they're the last people you want to be in a room with, right? So there could be a change. There could be a death, a divorce, a birth, for example. Or there can even be like a refocusing. You know, my clients who have older children choose their older children. Then later on, they say, you know what, my kids are fine. I just want to give to my grandkids, right? So that usually happens every 3 to 5 years. The last reason why it should be every 3 to 5 years, because your lawyer, if your lawyer has the kind of practice that is long-term, is you need to go over changes in the law. For those of us in California, we got a massive change in property taxes called Prop 59 that literally repealed Proposition 58. Property taxes are just crazy in California. And essentially, it was a limitation for heirs to continue paying the same property tax as their parents. And so it's things like this, Carolyn, that you need to make sure that your estate plan that you create, that you signed, for example, in 2005, you ask yourself, is it still current? So every year on your own, and you should be sitting down with your attorney team every 3 to 5 years.
Okay. Do I need a will or a trust? My friend told me that if I get a trust, I will also need a will. Please help. I am confused.
Got it. I think I touched on this with the pour over will, right? Because people are like, well, is it a will or a trust? So if you have a trust, you fund all of your assets in your trust. Your home needs to be titled in the name of your trust. Your Patelco bank account needs to be titled in the name of your trust. And your life insurance needs to list the trust as either primary or secondary beneficiary. Why secondary? So if you are married and you trust your spouse, then you put your spouse as primary and then your trust as secondary. If you're in a Brady Bunch situation, you list the trust as primary so that it can go to the boys if you're Mr. Brady and Mrs. Brady survives. Now, the reason why you need a pour over will is just in case you forget to do something. You have this backup safety net that says, I have a trust, it's beautiful. 9 of my 10 assets are in there. This 10th asset, I forgot, please put it in. And so it's a sort of an expedited way to include that 10th item back into your trust.
Okay. Here's another good one. Can I just list a beneficiary from my Patelco bank account? Do I need to retitle my account in the name of the trust?
Yeah. This is in the similar vein as the payable on death deed that I explained. It is an option, but in my humble opinion, it is not the best option, because I'm particularly concerned of this transition period where you're not dead. You're incapacitated. And in order for Patelco to release those funds, because it's payable on death, we need a death certificate. What if you're in a nursing home for 7 years, vegetative, incapacitated? They're not releasing that money until the death certificate is procured. If it was in the name of the trust, there is a provision in the trust that says if I'm incapacitated, my son, Thomas, is going to come forward. When you retitle the name of the trust at Patelco, they will ask you who can they expect to be the successor trustee, so that when Thomas comes, they're sort of greeting him warmly and it's an easier transition. So you can, but it's not the best. I'd prefer that it be retitled in the name of the trust.
I would also recommend for all of you that have financial advisors to talk to your financial advisor, whether it's a Patelco financial advisor or somewhere outside of Patelco, to have a beneficiary review. Now, financial advisors are not attorneys, but they are going to go through your products and make sure that maybe your beneficiaries on an annuity are still up to date, and if that's what you want. So on to the next question, and we'll be able to take probably 1 or 2 more. I have a special needs daughter. Do I need to set up a special trust for her?
Wonderful. This is another top 10. So, it is probably prudent and reasonable to sit down with a practitioner that is familiar with this type of trust. It's a special trust. So what it is basically is, there could be benefits for your child who has special needs that they are receiving from an agency or from any benefit. And some of these agencies, they don't care that you have other assets. But there are certain agencies, government agencies, that will require you to have depressed assets in order for you to collect if you have special needs, for example. One of them is quite strict. For example, you need to have less than $2,000 at any given time. So what happens if you pass away and then your child who has special needs receives assets to the trust and there is no provision? What we're trying to avoid here is the disqualification of your special needs child from continuing to receive benefits. And so there are provisions that we can include in a trust, which would make it a special needs trust, so that when your child receives the inheritance, it is not competing with what the government is giving to him or her. So that is a wonderful package where this trust is for them, but it supplements what they're getting. So for example, it could be that government aid doesn't cover certain dental benefits, doesn't cover travel if they want to visit family in Europe or the East Coast. And so what can happen is the best of both worlds, where they can collect from government and agency for support, but also use from whoever, mom or dad, right, to fill the gap or to financially support her in those areas that the government isn't. So yes, special needs trust. But now that we're talking about government aid, this is a hot topic, and then we'll transition real quick, Carolyn. It's this concept of Medi-Cal in California. Again, it's government aid again. You need to have depressed assets. But here's the thing. You can qualify even if you own a personal residence. The issue is that it used to be that when you passed away, the state of California can use your house to get repaid because they've given you so much benefits over the years. There's this good news. They've changed that about 5 years ago. state of California can still come back and collect after you pass it away against your house, if you're on Medi-Cal, for example. The issue is the only way they can collect is in probate court. So they can collect to get repaid, but in probate court. So all you have to do is set up that trust, because if you recall, one of the most wonderful benefits of a trust is that it will absolutely avoid probate. So we're at the 2-3 minute mark. I wanted to go over the email trust with an S at oakcrestlaw.com. Our number is 800-631-1881. We'll fix the QR code right away, but I wanted to have Carolyn close and take us home.
Okay, actually, we also put the link for the QR code in the chat. So not the QA, but the chat. So you can go over there and press on that. So we did take care of that on a different way. We did have a couple of questions, several questions about California. Ed does take care of clients out of California. You can talk to him directly or the firm about that. He lives in Southern California. He is not exactly local, but he is an attorney that is licensed in California. So he also works very closely with financial advisors. And we are here to tell you that our financial advisors definitely will be working with any kind of attorney that you work with. It's very important that they work together and that you have your CPAs and your attorneys and your financial advisors all on the same page. So we have 11 financial advisors that can help you make those decisions. They can help you with tax-free income, retirement planning, retirement income, 401ks, IRA rollovers, financial planning, long-term care, life insurance, and of course, wealth transfer. So they can meet with you in person, over the phone, or Zoom. And by the way, our financial advisors have an encrypted version of Zoom for that added online protection. So, and also I think Veronica added a link to in the chat to financial advisors if you want to find one that's near you. Or if you go back just a little bit, Ed, for if you don't want to do that, you can contact me directly, email me. Just make sure that you tell me what branch is most convenient for you. So the last page, last slide there. So here's how you could register for estate planning part 2, having an honest conversation with loved ones about your wishes. I love this webinar. It is just taking everything that you've learned today and wrapping it up into the emotions and getting it fulfilled for your family and yourself, and to be able to sleep at night. So Ed, just what a fabulous job that you did on this. I appreciate it.
Really good.
Yes, we didn't get a chance. There were over 200 questions. So we apologize again for not being able to get to all of your questions, but if you got the QR code, that's great. If you didn't, there's a link, there's an email address, there's the phone number, and Ed's team is waiting there to help you make an appointment, and of course the discount for Patelco members. Just make sure that you mention this webinar. So lastly, on behalf of Ed, Veronica, myself, the entire Patelco team, we thank you for attending tonight's webinar. Please check our website and join us for future webinars. Veronica does a lot of them on a variety of topics. And remember, wherever you are in your financial journey, Patelco is here for you. Thank you and have a wonderful night. Good night.
Thank you so much. Take care of yourselves. We'll see you next week. Bye-bye.
Bye.